I'm Dan Johnson. I'm from the Stamford office at Cummings and Lockwood, and I'm going to talk about planning for a client who has enough and is ready to make large gifts. I've been at Cummings and Lockwood for 21 years, and in that time, I know the one thing I've never said to a client is, you have enough, and we should start talking about making gifts right now. I've learned along the way that some techniques are not right for some clients. Jesse just talked about Cuperts. I've had the conversation about Cuperts with clients where we get to the part where we say, okay, now this is going to be great. You're going to give away the house. You're going to give it to the kids. We're going to do it on a tax efficient basis. There's going to be a certain term. At the end of the term, the kids are going to own the house and you're going to start paying rent. And I have literally gotten to that point and the client has said, stop talking about this technique. I'm not interested in it. I'm sure I'm not the only one here who's had the conversation with the Wall Street type who's very into investing, and we're talking about the possibility of whole life insurance, and it's an uphill battle because they say, why would I want to invest in something that's going to have a return like a bond? I can take care of this myself and guarantee a 10% return every year, et cetera, et cetera. And so that can be uphill. And then Jesse talked about gifting using annual exclusion gifts, and so we'll talk to clients, we'll say, you should make gifts to your kids. You should make gifts to your grandkids. If you're really wealthy, how about we start looking at other members of the family? How about your siblings? How about nieces or nephews? I hate my brother. I've never spoken to my sister. My nieces and nephews are losers. Let's stop talking about that. So you have to figure out what it is you want to focus in on with a client, and do they have an appetite for gifting? And one of my partners has a nice way of putting it. If the idea of making a gift gives you butterflies in your stomach, you should not do it, regardless of the tax efficiency. And something I've learned along the way is that it's not a good idea to prejudge the client based on what you think of their assets, whether or not they're a good candidate for gifting. I worked with a couple years ago in 2012. So we have in 2012 this situation where the exemption from the estate tax is $5 million, and we know it's going to go down if Congress does nothing at the end of 2012. It's going to go back down to $1 million on January 1st, 2013. So we're talking to really wealthy couples saying, hey, this could be a once in a lifetime opportunity. You want to give away these dollars if you can. And so this couple where they're worth hundreds of millions of dollars, this is a small fraction. Giving away $10 million does not move the needle for them in terms of their wealth, but they didn't always have hundreds of millions of dollars. And $10 million is real money to them, and the idea of giving it away made them uncomfortable. So we ended up doing spousal estate reduction trusts, different terms, funded at different times, not reciprocal, but they did give away their $10 million, but they did it in a way where they retained access to those funds, because even though this was money that they almost certainly would never need, they weren't completely comfortable with the idea of giving away and losing access to $10 million. I have another client that I work with. During the financial crisis, he had a primary investment account, and whenever that account gets below $20 million, he gets really nervous and irritable and hard to talk to. And so in 2008, 2009, that account dips below $20 million. And the idea of talking to him about planning, which he should be doing planning, he should be thinking about gifting, but it's a non-starter with that client in that situation. More recently, I was working with a middle-aged couple, again, high net worth, 40 million plus, and we're doing basic estate planning documents, sort of an upgrade to their existing estate plan. And we get to the end, we've done the wills, the revocable trusts, and powers of attorney and healthcare documents, and we're signing everything. And they say, okay, what's next? What should we be thinking about next? And naturally, they were doing their annual exclusion gifts to their children. So I said, the next thing would be to talk about significant gifting. And again, this is a couple that was originally from modest means, both of them, modest backgrounds. And they said, you know what, we're not there yet. Based on where we are, how we're spending, how we want to live for the rest of our lives, the idea of giving significant dollars away to our kids makes us uncomfortable. So you have to meet the client where they are. And so I'm going to talk about gifting. Some of you may recognize this is John D. Rockefeller, perhaps best known as the richest man who ever lived, now maybe known as arguably the richest man who ever lived. Jeff Bezos is giving him a run for his money. This is one of those things where it's hard to convey the scale of his wealth, but one good way to understand how wealthy he was and how powerful he was in the oil industry is to say Exxon, BP, and Chevron are all former subsidiaries of Standard Oil. So these three gigantic companies all used to be under one umbrella with John D. Rockefeller. And I'm no Rockefeller expert, so I did a little bit of research, and I came across this one sentence I wanted to share with you. It's from a quick article called "John D. Rockefeller was the richest person ever to live, period." On January 10th, 1870, Rockefeller incorporated the company that would make him almost inconceivably rich, and in many ways begin the modern age of oil. Its tactics were brutal, and he himself was ruthless, but he also gave an immense amount to charity. I think The reason I wanted to mention Rockefeller in this context, where we're all planners and advising clients, is there's an interesting model here of somebody who did have enough and was ready to do gifting, and he did it and was very thoughtful about both his charitable pursuits and how he planned for his family. And I have said to other advisors along the way, the Rockefellers kind of had a secret sauce. I mean, if you look at these high-profile families that had a lot of money, what's interesting is now one of his grandchildren, David Rockefeller, died in 2017. And if you didn't read that obituary in the New York Times, it's worth it, because that is a fascinating life of somebody who grew up very wealthy, but was very driven and did a lot of great things in his own life. And so in a lot of the families that we work with, we see things sort of start to drift as the matriarch and patriarch pass along. And here's a family where they're still engaged with society and doing a lot, and they seem to get along with each other. And as planners, it makes you think about the role that we can play in that process. I mean, very few of us, if any of us, are going to talk to somebody like John Rockefeller during our life, but we have a lot of little John Rockefellers that we all work with, and we can help them plan for their family, and we can help them have an impact on the society around them through the charitable planning that they do. So I'm meeting with a family, and they say, we have no tolerance for paying additional taxes for whatever reason. We want to do some planning, but we don't want to pay any more taxes. And Jesse just talked about the advantages of doing loans to individual family members. Suppose the family that I'm talking to says, but we do have a grantor trust. So this is a trust for income tax purposes where we've given money away to this trust during our life. It's outside of our taxable estate, off of our balance sheet for estate and gift tax purposes. For income tax purposes, its existence is ignored. So when the assets that I've given to this trust produce income, they get picked up on my personal income tax return. So when I do things with this trust, it's a non-event for income tax purposes. And so we say to that family, hey, instead of making a loan directly to the kids, how about if you make the same loan to this intentionally defective grantor trust? So the economics of that loan are just as Jesse described. You see the rates there. So I ran, if you did a 3-year short-term rate loan at 7% return over the 3 years, the amount that would be left over for the kids after the interest payments is $200,000. A midterm rate loan, same $2 million loan, producing 7% over the course of the loan. The excess going to the kids after you pay back the interest rate, the 3.04% in the principal, is $1 million. And then finally, I did a long-term 15-year, again, 7% return, $2 million loaned. The excess going to the kids is $2.3 million. So this is a way to get real money downstream to the kids on a tax-efficient basis and set them up to do things like buy a house, start a business, pay for their wedding. Why would you do this instead of just making loans directly to the kids? It has to do with the income tax character of the trust that I just mentioned. If you make a loan directly to the kids, when they're making interest payments back to you every year, that's taxable income to you as the person who made the loan. If the loan is to a trust that's treated as an intentionally defective grantor trust for income tax purposes, those interest payments still have to come back to you, but they're not taxable income. So in my example, I'll use the short-term rate loan. $2 million is loaned. The payments that are coming back to the person who made the loan over 3 years is another $230,000. If that's a loan directly to the kids, that's $230,000 of taxable income that is going to have to be reported on the returns of the person making the loan. If it's to a grantor trust, it's not a taxable event. So that's $230,000 of taxable income that's being avoided. That is something to consider for the right client. Now, a little bit harder. Let's suppose I'm meeting with a couple and they say, we've done some planning and now we've used up our exemptions and we feel like we have the latitude from a comfort standpoint of doing some additional planning, but our hands are tied. And a lot of times that perception comes from the loose understanding of most clients that the estate and gift tax system is a unified system. That is, the gift tax backs up the estate tax. We have a gift tax so that you can't be on your deathbed and say, I'm going to give everything away and avoid the estate tax at the time of my death. That's why Connecticut still has a gift tax, by the way, and that's why New York has a look back if you make gifts within a certain amount of time before your death. So clients get that. So the answer to that is to say, well, there's a certain tax efficiency to making gifts, even if you're paying taxes, and that's because the gift tax is tax exclusive and the estate tax is tax inclusive. What does that mean? And so if you say that to a client, you're going nowhere. And so this is the example that I use in meetings when I'm talking to clients about intentionally making taxable gifts. The assumptions here are we have $3 million that is available for planning, that the client has said, whatever we need to do with this $3 million, it's available to us. The tax rate is 50% for discussion purposes. That's close to reality here in Connecticut. And there's no remaining exemptions, so these are taxable dollars. So we say to the client, you could do nothing. You could just hang on to this $3 million. If you do, it's $3 million. It's going to be included in your estate. We're going to pay $1.5 million of tax, and your beneficiaries are going to get the balance, the other $1.5 million. Or we could make a gift. So we have $3 million available for this planning. Let's make a gift of $2 million. The tax is 50%. You're going to pay $1 million, and now the beneficiaries are getting $2 million, so an extra $500,000 by making the gift instead of holding on to these assets until the time of your death. Now, I've worked through that example with a lot of clients over a lot of time. Sometimes you have to go through it a couple of times, and eventually what they'll see is, I'm not paying tax on the $1 million that's being used to pay gift tax, and that's how I'm saving $500,000. The good news on the planning front is we're still in a historically favorable environment. Jesse mentioned the 75-20 rate, which is an important hurdle rate for planning purposes, is 3.6%. I take you back to Christmas Eve in 2001 when Dan Johnson, am sitting in the lobby at Cummings and Lockwood late in the afternoon on Christmas Eve wanting to join my family. It is me and the security guard. My partners are gone, the associates are gone, the staff is gone. And I have just called FedEx because I have a package I want them to pick, which I didn't even know that was possible before that day, for me to individually call FedEx and have them come pick up a package. Why did I want them to pick up this package? Because the 75-20 rate in December of 2001 was 4.8%, which was, we considered very low at the time. And it was scheduled to go up to 5.4% on January 1st of that year. And so I wanted to make sure I had a client who was going to fund a grant. We wanted to make sure they signed it and funded it before the end of the year. And so we had to get it out so that it was delivered to them on December 26th or 27th, I can't remember. So now we look back at that, and it almost seems quaint because the 75-20 rate hasn't been above 4% since 2008. So we're at 3.6%, I'm not the economics expert in the room, but it does seem like interest rates are climbing slowly and surely. And so we may get back there again. But again, we're at 3.6%, and nothing is happening suddenly. So this is still a good opportunity to take advantage of low interest rates. This slide, this could be a leftover from last year, and it's just saying the 2704 regs were withdrawn in their entirety. And so that's really actually a review. The 2704 regs had to do with evaluation of closely held business interests, and these were withdrawn before we did this meeting last year. The reason I kind of bothered to put it in is I love, in the second bullet point, the second quote, which is directly from this report to the president from the Treasury. Taxpayers will not be able to determine the value of an interest based on the fanciful assumption of a world where no legal authority exists. What's amazing to me about that is this is written by the same department that issued the model regs. So, whoever wrote that works with the person who wrote the regs, and you hope that those two don't sit near each other or have to work closely with each other. Lastly, Rachel Zargami mentioned this at the beginning of the day, so I just want to underline it. There are proposed regs that eliminate the clawback. So for families that are thinking of giving away their new $11.2 million exemption or any increased amounts in the future, and they're worried about, okay, if I do that and we get to January 1st, 2026, and the exemption goes back down to $5 million adjusted for inflation, am I going to have to pay tax on those dollars that I gave away that were tax-free when I gave them away? And we had been hearing from the IRS along the way at seminars where they were speaking, and parenthetically I should say, the tax bill said, it instructed the IRS, you have to issue regs to address this point. You have to address the potential clawback issue. And that was a hangover from 2005, because that was a major issue as we were all doing planning in 2005 and giving away dollars. What happens if there's a clawback? And so that issue resonated with Congress. They instruct the IRS and Treasury, you have to address this with regs. IRS is going around, the speakers at conferences all over the country are saying, our intention is to issue regs that will eliminate the clawback concern. And so it was a relief to us last week when we see the proposed regs and they actually do eliminate the clawback. So hopefully we get those finalized. I'm going to talk about an installment sale because it's a technique that takes advantage of a couple of things I just talked about. So the fact that the 2704 regs were withdrawn in their entirety, so we can still take advantage of closely held business discounts. we have low interest rates, and we don't have the same concern about the clawback that we might have had even potentially as little as a week ago. An installment sale is the sale of a business interest to a trust in exchange for a promissory note. And so in my example here, I'm using Homer Cummings. Homer, maybe some of you don't know, Homer Cummings is our founder, Cummings and Lockwood. He was the Attorney General under President Roosevelt. That's a worthwhile Wikipedia read if you have a second. There's actually a movie about a story about him, and that's worthwhile too, called Boomerang. In this kind of a sale, in my example here, the business interest that Homer is selling is an LLC interest, and the underlying value of that interest is $16 million. But the sale value is not going to be the underlying value. It's going to be the discounted value. And so for valuation purposes, we're going to go out and we're going to get an appraisal, and we're going to say that there's a 35% discount. So what we think might have an underlying value of $16 million, we're going to sell it to a trust for Homer's family for $10.4 million. We're going to sell it in exchange for a promissory note. That promissory note is going to use the midterm rate, and it's going to have a 9-year maximum term. During the term, Homer's going to receive interest payments. So you can see the $316,000 that's going back to Homer every year for the 9 years. And that's a balloon note. So at the end of the 9 years, he's going to get back $10.4 million. When we're setting this up, we have to provide security for the note. The IRS has said in order for a sale like this to look legitimate, they have said in other contexts, the family trust that is purchasing the interest from Homer should have a value at least equal to 10% of the value of the note. And so that's 10% of $10.4 million, so $1,040,000 has to get into this family trust at the outset. And so how do we get it there? We could put our head down and just make a gift, say, hey, Homer, use $1,040,000 of your exemption from the gift tax and just put in cash or securities. Or maybe we're planning in advance. Maybe this is a trust that he's been making annual exclusion gifts to for his children or his grandchildren. Or maybe we fund it using a grant. So there's a lot of ways to get those dollars into that trust. Once we have $1,040,000, now we're set up for this potential sale. The sale succeeds in a couple of ways. One, to the extent the value of the business interest grows at a rate higher than the midterm rate, the rate that we're using on the note. So the rate on the note, you can see in the upper right-hand corner, is 3.4%. If the business is growing at a value in excess of that, that excess value is going to remain in the family trust. But also, to the extent that our discount is upheld or successful, that excess value is staying in the trust. So again, I was saying we're selling something worth $16 million. We're saying that the sale value is 10.4, so that's $5.6 million that's going to the family tax-free as long as we don't have a problem or an objection from the IRS to our appraisal. So when you hear those kinds of dollars, you can understand why this is a popular transaction with clients, because it's a way to get very significant assets downstream. I would say the biggest transactions I've seen in my career are installment sales involving closely held businesses. The other thing that clients like about this, and the reason it applies to some of the biggest transactions I've seen, is it is scalable. So, this is an example of a $16 million interest in a business. In order to effectuate the sale, we only need an upfront gift of $1,040,000. But suppose I want to sell an interest worth $100 million to this trust. To have the security I would need for that note, I would need to get $10 million into this family trust. And when the exemption was $2 million or $3 million or $5 million, that seemed like a major issue. But in a world where the exemption is $11.2 million per person, getting $10 million into a family trust feels a lot less difficult than it used to. And as a matter of fact, obviously, 2 times 11.2 is 22.4. That would secure a $200 million sale into a family trust. So this is a very popular technique with clients. It is not a very popular technique with the IRS. They do not like this transaction, and that's one of the reasons for the 2704 regs. The 2704 regs were a direct frontal assault on this kind of planning. So if you're talking to a client, I think it's worthwhile to mention, hey, this is not Grats and Cuperts come directly from the code, and as long as you dot your I's and cross your T's and file a gift tax return and attach the appropriate appraisal, it's a very safe, almost risk-free transaction. That's why people like Grats so much, and that's why Cuperts have historically been popular. Installment sales are riskier because the IRS does not like them. They do not like this valuation discount idea. 2704 regs could always come back in some better, improved version in the future. There's some 2036 dangers. 2036 has to do with retained interest in property that you've given away. One 2036 concern is, what if the appraisal gets attacked for some reason? The IRS comes in, they say, hey, you took a 35% discount. but the appropriate discount wasn't 35%, for opening discussion purposes, it was 0. It was 5%, it was 10%. If they say the discount is 0, now you have a client who has sold an interest worth $16 million in exchange for a note valued at $10.4 million, which is a potential $5.6 million gift. So that's a real concern to bring up with a client. The other thing is, you saw in my example, the interest payments that were going back to Homer were just flat based on the interest rate of the note. The note payment was going to happen every year. Sometimes these notes are drafted in a way where the interest payment is tied to the income that's being produced by the business interest that was sold. And that's very dangerous because that, for 2036 purposes, that looks like the donor gave something away but retained an income right, which is directly prohibited by 2036, or prohibited in the sense that the IRS will say, okay, you retained an income interest, we're going to bring that asset back into your estate. I talked about the security for the note. Again, that 10-to-1 ratio saying the trust asset should be at least equal to 10% of the value of the note. That comes from the commercial context where the IRS has said, here's what a sale needs to look like in order to look like a legitimate sale. It's okay to have security in excess of 10%. And as a matter of fact, you could argue, make a strong argument, that's advisable. Don't just do the minimum. The danger there is if you don't, for some reason, have adequate security for the note, there are valuation issues that could come in under 2702 and really give you a painful bite. So you want to avoid that. Another risk of this transaction, if your seller passes away, so if Homer passed away in my example, and he's sitting there at the time of his death holding a promissory note from a family trust for $10.4 million, that's kind of a signal to the IRS that, hey, there was an installment sale, and it's an invitation to them to look at that sale. And then finally, this is another repeat from last year, but there was a decision in the tax court last year, Powell, in which the tax court ruled in a case in which someone had given away an interest in a business but also retained a piece of that business. And under 2036, the IRS said because that retained right gave the person a voting interest in whether or not the entity was terminated, so that person could vote together with the interests that were gifted to this trust for the benefit of family members. There was a retained right to vote to terminate the business. As a result of that right under 2036, that entire interest should come back into this person's estate. So Powell really scared people like me who do this kind of planning for a living. One thing I think that's important to note, like a lot of the 2036 cases, particularly in the partnership LLC context that we've seen, it was very aggressive, bad facts, deathbed planning. So a lot of us, I think, have a little bit of skepticism about how the IRS would treat much better facts. But it's an important enough decision, and it's based on a concept that the IRS brought up years ago in a case called Strange that we want to bring it to clients' attention before they do this kind of planning. So let's suppose that I'm sitting with a client, and I talk about an installment sale, I talk about the risks of an installment sale, and they say, okay, I get it. Thank you for the warnings. Let's go ahead. Now, I have listed here, these are some of the most popular dynasty trust planning jurisdictions. And I'm going to assume that a lot of people in this room have been to Nevada, New Hampshire, or Delaware. But just for my own edification, how many people in this room have been to Alaska? Okay, so for the purpose of the video, I'm going to say that was 20 to 30 people. And how many people in this room have been to South Dakota? Okay, so maybe slightly fewer, maybe 15 to 20. I asked that question because when you initiate this kind of a conversation about clients, about the advantages of going to another jurisdiction to do planning, that is not an irrelevant factor, their familiarity with the state and what's going on in that state. And so this list is kind of superficial considerations. Now, these are the top, I would say this is top tier dynasty trust planning jurisdictions. And so the different considerations here, trust friendly sense, okay, that's basically when did you have favorable trust planning legislation? And the reason that's relevant is that a jurisdiction that has had this kind of legislation longer is more likely to have a friendly legislature and or court history that gives us a sense of how well those statutes are performing. You could have a perfectly drafted statute, but if you have a hostile judiciary or legislature that might be changing those statutes, that's a potential cause for concern. The financial soundness of the state, why is that relevant? It's relevant because, I should mention, none of these states have a state income tax, but Alaska has proposed a state income tax, and so that's a concern. If you're setting up a dynasty trust in a jurisdiction, one of the things you like about that jurisdiction is there's no state income tax. What if the oil and gas industry is getting hammered and that has a negative impact on state revenue in Alaska and they start to flirt with a state income tax? My guess, for what it's worth, is that if Alaska did pass a state income tax, that it wouldn't apply to trusts, but that's just my guess. The point about population, that's really saying, what talent pool is available to these trust companies to administer the trust. And so when you look at this chart, and this chart was based on data that I took from an article drafted by somebody, or co-author at least, was from Wilmington Trust Company. So this was a Delaware favorable article. And that's probably obvious when you look at the chart. If you have a client who's serious about this kind of planning, you want to get a little bit more granular. And so the name that's probably relevant, this chart, and you can see in the first column there, it's Steve Oceans, who's a estate planning attorney in Nevada. He's very well respected. If you read his bio, the thing that jumped out to me is he's in the Estate Planning Hall of Fame. He was elected in 2011. I'm probably not the only person who realized there was an Estate Planning Hall of Fame before I read that. And I will never go there, I know that for sure. But Steve has he's made a reputation in many ways. He's a very well-respected speaker. He does a lot of writing. But he's probably best known to people like me because he prepares a bunch of charts every year ranking states for different purposes. And so there's a domestic asset protection chart ranking the states. There's a dynasty trust chart, a trust decanting chart, and then the non-grantor state income tax chart. If you want to, you can do a deep dive into how he creates this charts and his methodology, and it's kind of like mock draft or NCAA tournament bracket, who cares? But it's a pretty good source for looking at things at a superficial level. And I tried to pick out, these are not all the things that are in the chart, but I tried to pick out some of the things I thought were most relevant. And I will say, when you're talking to clients about the rule against perpetuities, my experience is that if you say to a client, you're choosing between 365 years or 1,000 years or forever, most clients will say 365 years is probably long enough. Amongst that list, that's the one thing that 365 years is fine for my family. And that we have that experience, many of you know, or probably all of you know, we have offices in Florida, and the rule against perpetuities, which is how long a trust can last, is 365 years in Florida. So that's a conversation I've had many times. Clients do care a lot about asset protection planning, and so when you look at the fourth column there, protection against divorcing spouse, you can see Delaware and New Hampshire suffer a little bit because there's some potential creditor issue in play for dynasty trusts in those two jurisdictions. And then the last column, which is another, so I'm referring to a chart within a chart. This is Steve Ocean's rankings for decanting purposes. Clients do like to know, okay, we have the ability to change this trust if we need to in the future. We can take the assets of this trust and pour it into another trust if something happens that changes how we want to administer the trust. What else will clients be looking at in this arena? They want to know that they're dealing with modern trust laws. And probably the most important aspect of this is the possibility of having a directed trust statute. And so what a directed trust statute enables us to do is either bifurcate or trifurcate the responsibilities of the trustees. And so if you've done this kind of planning or seen this kind of planning, what we're used to seeing is saying, okay, here's the administrative trustee. So I want to be in Delaware, Nevada, Alaska, South Dakota, New Hampshire, et cetera. I have to get a trustee in that jurisdiction. So that's my administrative trustee, the person who's going to receive all the mail for the trust and save all the income tax returns. I want an investment trustee. That's the person who's going to manage the investments of the trust. And then I have a distribution trustee who's going to decide when and if assets leave the trust for my beneficiaries. And so what clients like about that is I can select people for those roles based on their skill set. I don't have to have one person who covers that entire bandwidth of responsibility. If I have somebody who I think is really good at investments but is not great at communicating with my family, they're a good investment trustee. If I have somebody who's great at communicating with my kids about their concerns, but I wouldn't want them managing my assets, that could be potentially a good distribution trustee. The other thing that's good for clients about this is it enables us to get into these jurisdictions and frequently get a discounted trustee commission in the jurisdiction where we're hiring the administrative trustee, because we can say to the administrative trustee, you're the administrative trustee, there is potential liability associated with that, but ultimately you're not responsible for investing the trust assets, and so you're cut off from the most significant potential source of liability, and so as a result, is there a secondary fee schedule for reduced services? And frequently the answer to that is yes. Clients like if there's a trust protector statute, and I'm going to come back to that in a second, talk about what a trust protector is and what they can do. Clients like decanting, and so not only do we want to see a decanting statute, we want to see how flexible it is. We want to know not only can we pour assets from trust A to trust B, but for example, can we add beneficiaries? Can we subtract beneficiaries? What does the statute enable us to do? is there a virtual representation statute? If we're going to be doing things with this trust, do we have to contact all of the beneficiaries, or is there a virtual representation statute where somebody can stand in for all the beneficiaries and streamline the administration of the trust? And then finally, is there a quiet trust statute, which is a statute that talks about required communications with the beneficiaries? Some of these are incredible. I mean, in South Dakota, you have to tell the beneficiaries very little. You can have a court proceeding, and that proceeding can be sealed forever. Frequently, there's a time limit on the kinds of communications that have to happen with beneficiaries. So, for example, in Delaware, I believe the rule is that if there's a court proceeding, you don't have to tell the beneficiaries about it for 3 years. So that's an interesting concept. It's appealing to many families that, especially with minor kids or kids who are early in their careers, we don't have to tell them what's happening in this trust. I will say there's a little bit of tension here between what's allowed by law and what some trust companies are allowed or not allowed to do, but what they're willing to do. Some trust companies will say, we know that there's a quiet trust statute, but we're very hesitant to participate in a trust where the beneficiaries aren't going to know anything about this trust for a significant period of time. So that's part of the conversation with the trust company is, okay, you have a quiet trust statute in your jurisdiction. How do you guys handle that statute in light of the concerns of the family that I'm working with? Jesse touched on this a little bit, and this is once you set up a dynasty trust for a family, what are the protections of that trust? And my experience is the normal family is going to say, what we really want is for these funds to be available to our kids and our grandkids if they're good people. So if they're productive members of society, if they're working hard, it's okay to make distributions to them for their health and their maintenance and their accustomed standard of living and to pay for educational expenses. And most families say, if they're not that, if they're kind of deadbeats, then I'd be okay with the idea of cutting them off. The concern about putting an ascertainable standard, so a health, education, a custom standard of living, putting that kind of language into a trust document for the benefit of your family is, in some jurisdictions, Connecticut happens to be one, that creates a floor on distribution so that the beneficiary, if they see that kind of standard in the document, in some jurisdictions, you can actually go to a court and order the trustee to make distributions to help maintain your custom standard of living. So what we will usually say to clients is, I hear your wish, which is the most common wish for the families that I'm working with, but consider this. Consider saying in the trust document that the trustees have complete discretion over distributions of income and principal. And then if we want to refine that advice, let's do it in a non-binding memo that's outside of the trust document so that you can say in that memo, you can tell the trustees everything that's on your mind, but it's not ultimately binding on them. So that, if you say, if I have a child who's a good child and they're a productive member of society, under ordinary circumstances, my hope is that you would terminate this trust at 40 and distribute the assets to them. And it turns out that child is a spendthrift or has a substance abuse problem. The trustee can say, okay, that's why the memo was non-binding. Under the circumstances, we're going to keep these assets in the trust. And those memos are funny to write with clients. My experience is about 75 to 80% of clients will say, I want something that looks like the ascertainable standard, health, maintenance, custom standard of living. I had one couple that I worked with where these instructions stretched out to 4 pages and they were very detailed, involved, GPAs and earnings and automatic distributions. Now that can be dangerous, but it was a way for them to convey to the trustee exactly what they wanted. So what happens if you do what I'm suggesting for asset protection planning purposes and you say, there is no standard, the trustee has complete discretion, now that prevents this trust from being an asset in the hands of the beneficiary. And so, especially if there is no regular pattern of distributions and there's a divorce or another creditor event, since there's no property right because there's no required distributions, it's very difficult for a divorcing spouse or another creditor to get at that trust, to get at those trust distributions for purposes of making claims. However, and this is a point that's worth repeating, Jesse had raised it, what a court will look for is a regular pattern of distributions. And so if this kind of a discretionary trust, the trustee has complete discretion to make or not make distributions, and the trustee is exercising that discretion and saying, I'm going to distribute $100,000 to this beneficiary every year, a court will look at that and say, I get that the trustee can turn off this distribution, but the fact of the matter is, for the last 10 years, they haven't, and the beneficiary has been getting the same amount every year for the last 10 years. I'm going to assume that that pattern will be maintained going forward. And so when I'm creating an order, a judgment based on what this person has, I'm going to include that $100,000 per year in the pot. So if you're advising a trustee or you're acting as a trustee and you have this kind of broad discretion to make or not make distributions and you have things on autopilot, and there's a potential creditor event on the horizon, you just have to be mindful of the fact that a pattern of distributions can subject those trust assets to a potential claim by a creditor. Just a minute on trust protectors. A trust protector is a person that is designed to react to the circumstances on the ground. I've heard them described as the eyes and ears of the settlor. So the settlor is gone, and they want somebody watching the trustees, watching the beneficiaries, watching the laws, and seeing what should be changed, if anything. So the protector can have the power to modify the trust, to address changes in state law, in the Internal Revenue Code. If there is an automatic distribution that's going to happen to somebody who has a substance abuse problem, the protector can step in and potentially remove that withdrawal power. If there are other creditor issues, the protector can change the terms of the trust. They can add and remove beneficiaries, and so it's not uncommon to see a protector who has the right to add a spouse of a descendant as a beneficiary of this kind of a trust, or add a charity or remove a charity. Maybe a charity falls out of favor for some reason, and so the protector can swap in a replacement charity. And then finally, the protector can initiate the process of changing the jurisdiction of the trust. So in my example before, if Alaska were to pass a state income tax that applied to trust, and the protector said this is not at all what the settlor had in mind, they can step in and start to change the jurisdiction of that trust. One thing, a note I should make about adding or removing trustees, one thing that settlors, the people setting up trusts, like about the protector having the ability to add and remove trustees is it's a more objective exercise. This is obvious than if a beneficiary has the right to remove a trustee. So, to be candid, I frequently give the beneficiary the right to remove a trustee of his or her trust, usually subject to some restrictions about who successor trustee can be and what age they are, and potentially they have to have buy-in from other siblings or other family members. But for some clients, they say, I don't want the beneficiaries to have that right. Let me give that right to a third party. And so if I have a beneficiary who's just unhappy that they didn't get a distribution, or there's a personality conflict with the trustee who's otherwise doing a good job, a protector can be an independent person to come in and make an objective judgment about whether or not it's appropriate to remove a trustee. That is my speedy tour through planning for high net worth families.